Okay, hello everyone, welcome back. We have finished with the concepts of strict and absolute liability as well as your general conditions of liability in tort. Now we're coming to the third type of liability, that is known as your vicarious liability. What exactly is vicarious liability? It is also a type of liability, but they're saying that over here the act is done by one person, by say the wrongful act or the omission is done by one person, but then some other person is being punished for the action of the other. So in the sense that generally if I commit the wrongful activity, then I will be punished for it. But in vicarious liability they're saying that the act was done by somebody else and I am being punished for his activity. There'll be very specific situations where only if there is a relationship between me and that other person can I say this concept of vicarious liability even arises. So this principle came up during the rise of what we call as the master-servant relationship, or more specifically they were considered as slaves who were governed by their masters. Today we don't call them slaves because we don't have slavery, but we do end up calling them servants. Now this master-servant relationship can also be seen through your employer-employee relationship, between partners, between a principal and the agent. We'll be looking at each one of those relationships individually, but for vicarious liability to exist, there must be some kind of a relationship between the master and the servant, whether it is in employment or in some capacity that brings both of them together. The servant must have committed the tortious activity, and the tortious activity must have been done during the course of employment. If these conditions are there, then vicarious liability will exist. So let's look at the different relationships that exist between a master-servant or a relationship which gives rise to vicarious liability. The very first one that we have is your principle of agency, or in short your principal-agent relationship. Now this principal-agent relationship is a very specific authority, in the sense that I could be the principal and I can give the agency to one person to book my flight tickets for me, or to book travel tickets for me. I can appoint an agent to carry out my company's work in a different country. So this is a very specific authority between a principal and an agent, and they're saying that he who acts through another is acting by himself. It follows this legal maxim, that is your qui fecit per alium facit per se. He who is acting through another is acting himself. So let's look at the first case law, Lloyd versus Gray Smith and Company. A managing clerk in a firm of solicitors, while in the ordinary course of business, committed fraud. That is, she asked a lady client to fraudulently sign documents transferring property over to him. So who is the managing clerk? The managing clerk is a person working in the firm, and while getting her to sign certain documents, he also got her to sign documents to transfer certain property to him. He had done so without the knowledge of his principal, but the principal will still be held liable because the fraud was committed in the course of employment. So there is no requirement as to whether the principal was aware of it or not. He will be held liable so long as there was a wrongful activity done during the course of employment. Partners. Now, partners itself act in mutual agency of each other. That means one partner is the agent for the other, and that partner is the agent for the other. So we call this as a case of mutual agency. When a tort is committed by the partner in the ordinary course of business, all the partners will be held liable to the extent of the guilty partner. So let's look at the case of Hamlin versus Houston and Co. One of the two partners bribed the plaintiff's clerk and induced him to divulge secrets relating to the employer's business. It was held that both the partners were liable for the tort, which was only committed by one of them. Next, we have the master-servant relationship. Here again, we've already seen where the servant has committed an activity in the course of his employment, then the master will be held liable for his actions. Okay, so this requires the master to be liable for acts committed by the servant. The master is still liable for acts of the servant even if it's unauthorized, as long as it is in the course of employment. Employer and independent contractor. Now, please understand that all the relationships that we've seen so far are between master and servant, between partners, and between principal and the agent. Here there is some kind of a relationship between them, whereby the employer is asking these people to do certain activities. But there is another person who may come in the capacity of conducting work for another person, and that is an independent contractor. Okay, so who could be considered as an independent contractor? Let's say the engineer and the architects who are building your house for you, they will be independent contractors. Or let's say that you want to build an app. If you want to build an app, you'll have to appoint some software developer who will build that app for you. So those software developers are not in your employment, but rather they will be doing this one project for you, and they will be considered as independent contractors. Tell me, is it possible for an employer to be vicariously liable for the act of an independent contractor? Because in the past examples, we've seen that these people were under the control of the employer or control of the principal or in mutual agency of each other. But in this case, the independent contractors are not in employment. They are using their own separate set of skills and their own judgment when they are doing certain activities. So generally we'll say that an employer is not liable for the actions of his independent contractors. Okay, so let's just look at when the employer is not liable for the act of the independent contractor. He is not liable for the act of an independent contractor if he has taken care in the appointment of a contractor. That means as long as the appointment process was proper, okay and correct, then any activity done by the independent contractor will not be considered as the master will not be held vicariously liable. The independent contractor himself will be held liable for these actions. In Phillips versus Britannia Hygienic Laundry Company, the owner of the lorry was not liable when a third party's vehicle was damaged in consequence of a negligent repair of his lorry by the garage proprietor. This is a very specific point. The owner of the lorry was not liable because the lorry, even though it caused damage to the third party vehicle, it was due to the negligent repair of the lorry by the garage proprietor. Now, there are some situations in which the employer will be held liable for the acts of the independent contractor. They're saying there are exactly 3 situations when the employer authorizes him to commit a tort. So, the employer itself has asked the independent contractor to do an activity which was likely a tort. In torts of strict liability, because remember in strict liability in Rylance versus Fletcher, the objective was not to find out who did the wrongful act, but rather the wrongful act is already committed, and it is, if we keep pointing fingers and blaming others, then in that case the victims will not be given the justice that they deserve. So for cases of strict liability, the employer will be held liable in the case of an independent contractor or the negligence of the independent contractor. So these are the three situations in which the employer is liable for the acts of the independent contractor. So please take out 5 minutes to read the provisions that we have done so far, and we will continue with this concept of vicarious liability of the state. I hope all of you have finished going through everything that we've done so far. Okay, so we're now going to be continuing with the second half of vicarious liability. That is, we're going to be looking at vicarious liability of the state. Now, why are we talking about vicarious liability of the state? For this, you need to understand that governments itself is one of the biggest employers. So can I say that there is a employer-employee relationship even with respect to the government? Okay. Now, the question here was, when we refer to the government is a fairly new concept because of democracy. But before we had governments, we had the crown. In short, it could be the king, it could be a queen, a monarch, etc. Okay, so if we had government employees that are committing torts, then as per the principle of vicarious liability, the general rule is that the employer or the master will be held liable for the actions. But please understand that in prior to 1950s itself, I can say, the general rule was the king can do no wrong. The king can never do anything which is wrong, because any action of the king itself was considered to be law. So how can we punish a king for an activity that his servants have committed? So using this concept only, we have to look a little bit in detail regarding vicarious liability of the state. Now, if you have to look at it in England, there was something known as the Crown Proceeding Act of 1947. Prior to this, they said that the crown can never be punished for any action done by its servants in the course of their employment. So, the crown could not be sued in torts, either for wrongs actually authorized by it or committed by its servants in the course of its employment. So even if government servants did any kind of a tort that was either on their own or it was authorized, regardless, the crown will never be punished. But then After the Crown Proceeding Act of 1947, there is a complete 180-degree turn in terms of the applicability of this rule. They're saying that now the Crown will be held liable, just like private individuals. Now, this is the position in the case of England. We have the Crown Proceedings Act of 1947, there's prior to that and there is subsequent to that. But then in India, unlike this Crown Proceeding Act, we don't have any kind of a statutory provision with respect to liability in India. Then how exactly do we look at liability from an Indian perspective? For that, ultimately it came down to the difference between sovereign and non-sovereign functions. But to understand sovereign and non-sovereign functions, we must first come down to the case law known as State of Rajasthan versus Vidyavati. Now, the facts of this case goes on to say that there is a jeep. This jeep is a government jeep that has been given to the collector for his usage. Now, the collector will be given a car and also a driver for the purpose of driving the car. So what exactly this driver would do was he would turn up for work in the morning and he would drive the collector around. In the evenings, once his work was over, he'd take the car and then he'd leave back home for the purpose of taking the car and coming back the next morning. Now, after he has dropped the collector of Udaipur, he happens to be driving the car and he ends up hurting a person on the road. And the injured person ended up dying 3 days later in the hospital. Eventually, the legal representatives sued the state of Rajasthan and the driver for compensation for the act committed by the driver. Here, the court simply said that, see, there is a case of rash and negligent driving of the driver, and in driving the jeep, he had ended up causing the death of an other person. Finally, it came down to the Supreme Court itself, where they held that the state must be held vicariously liable for all the torts committed by its government servants. So this is a fairly simple provision. The principle is saying there is a case of vicarious liability over here. Correct? But this ended up proving to be quite disastrous for the government, because if every single government servant had to commit a tort, and if every single time the government is paying out compensation in money, then don't you think it will become a very bad case for the government if they are spending their time in courts and paying out compensation in money rather than governing or administering the country? So if this was to happen, then it would be a very grave problem in terms of administration in our country itself. So even though in the state of Rajasthan versus Vidyavati, the court held that the state is vicariously liable, subsequently in the case of Kasturilal versus UP, the court went on to make a small distinction. They said that there is the case of sovereign functions and non-sovereign functions. And in which case law did they discuss this or decide this? It was in the case of Kasturilal versus state of UP. So let's look at the facts of Kasturilal versus state of UP. The plaintiff was arrested by the police officers on suspicion of possessing stolen gold or property. Large quantities of gold was found and seized under the Code of Criminal Procedure. Ultimately, he was released because there was no case of wrongdoing, but the gold was not returned because the head constable had absconded with the gold. He saw all that gold, he stole it and he ran off. Now, the plaintiff eventually ended up bringing a suit against the state of UP for the return of the gold and for the damages or losses which was caused to him. Now, here the court ended up taking a very different decision in terms of this case. They admitted that yes, the head constable did run away with the gold and there is a case of theft over here. But what the court also said was the action of seizing the gold was actually a statutory power granted to the UP police under the UP police regulations. So since the UP police were granted statutory powers to confiscate and seize, they only happened to be negligent in the process of the seizure. Okay, and the court went on to say that the powers to arrest a person, to search him, to seize property, etc., are all powers which are granted by statute. That means only a law can grant these powers to these authorities. And if there is this kind of power, we'll call that as a sovereign power. And so while the court went on to agree that yes, there was negligent activity committed by the head constable in the course of his employment, and technically it is true that the state will be held vicariously liable. However, since it was of a sovereign nature, there will be no case of liability over here. Okay, I hope you have understood. In vicarious liability, the master will be held liable for the acts of the servant. In this case, the court is saying yes, there is vicarious liability, but the only problem is that some powers are being exercised under law, making it a statutory power. Now, when it becomes a statutory power, we can call it a sovereign function, and sovereign functions are protected from the court of law. Or in other words, it's protected from immunity. And that is why we'll come back over here. In India, if the government servant is performing sovereign functions, then they will get immunity from the courts of law. But then if there are non-sovereign functions, then there will be no immunity from the courts of law. And this is actually a very interesting provision. How did they come about sovereign and non-sovereign functions, and where did they come out to say that in case of sovereign functions there will be immunity from courts, and in case of non-sovereign functions there will be no immunity from the courts? Now all of this was great, but our next question became what is sovereign functions and what amounts to non-sovereign functions, which for a very long period of time was not answered by the courts of law. Okay, and finally in the case of N. Nagendra Rao versus State of Andhra Pradesh, the court went on to bring about that example in the bring about the distinction between sovereign and non-sovereign functions. But you see, this took some time and understanding, because the first thing they said was, okay, let's try to understand what is of a sovereign nature. What are those things that only a government can do? Because if the government can do it and the private persons can do it, then it doesn't become a sovereign function. A sovereign means any highest authority in the land. Okay, so let's look at some examples. The defense of the country, raising armed forces, making peace or war, foreign affairs, and the power to acquire and retain territory are all certain examples of external sovereignty and are political in nature. So we can say that if any of the above activities are being done, then the state is protected from being sued. Okay. The court also went on to state that the state cannot have absolute power with regards to the same. any suit by the common man against an officer or employee for negligent activities must be given thought. But the problem is, today our country has become a welfare state. That is, apart from these functions that we see, the government is now taking up even more responsibilities. They are taking up even more actions and activities on a daily basis. So the government is not just defending our country, they are also providing food and education and shelter and clothing. They are providing these at subsidized rates, and they are ensuring that everybody has equal opportunity. Correct? So when our government is a welfare state, then technically any activity that it does would amount to a sovereign function, because it is the function being governed by the sovereign. This gave rise to even more confusion before the court of law. And so the court simply came out and said, listen, I am only going to classify the following as sovereign functions: where there is administration of justice, maintenance of law and order, and repression of crime. Apart from these three factors, the state will not be allowed to claim immunity for negligent acts committed by its agents. So let's quickly break down. In the case of the state of Rajasthan versus Vidyavati, the court held that there is a case of vicarious liability. But in the case of Kasturilal versus state of UP, they said yes, there is vicarious liability, but not vicarious liability. They said that there is a case of negligence, but no vicarious liability. And then finally in N. Nagendra Rao, the court held the difference between sovereign and non-sovereign functions. Okay, the court went on to specify that even though we are a welfare state, the following activities only would amount to a sovereign function. And so this, guys, is the end of your concept of vicarious liability as well as vicarious liability against the state. Now the doctrine of immunity is where I told you that the king cannot be sued in his own court of law. Okay. We're now coming to the last topic in your Law of Torts chapter, that is known as your torts relating to personal safety and freedom. So the different types of torts or wrongs to personal safety and freedom are as below: battery, assault, bodily harm, false imprisonment, malicious prosecution, nervous shock, and defamation. Let's look at each one of them individually. A battery is the direct application of force to the person or another individual without his consent or lawful justification. So if a person goes and hits someone else without their consent, then it is battery. For battery to exist, there must be two essential factors. There must be a use of force. It may be without the plaintiff's consent, and there is no lawful jurisdiction for doing this. That means nobody is justified in hitting another person. Okay. However, for battery to exist, there must be the use of force. Even though the use of force can be trivial and does not cause any harm, the wrong is committed. To touch a person without lawful justification is considered as battery. However, if someone does come to attack you, you are allowed to use reasonable force to protect yourself, and that is what we call as defense. In Coward versus Badley, they said that touching a person with not more than the reasonable force is not battery. In Sitaram versus Jaswant Singh, they said that the occupier is entitled to expel a trespasser and forcibly remove him from his premises, but it should be reasonable and not greater than necessary. The next one is assault. Assault is any act wherein it causes an apprehension in the mind of the person. So if a person threateningly comes to walk towards you and you have a feeling that he may cause you harm, then there is a case of assault over here. And lastly, we have bodily harm, which is a combination of assault and battery. There is a reasonable apprehension in the head of the person and followed by physical force being taken place against his body. So battery, assault and bodily harm are completed. What do you mean by false imprisonment? False imprisonment is some kind of total restraint for some period of another person. We've seen that Article 21 protects our right of personal liberty. The same way over here, if you take away the personal liberty of some person without any lawful justification, then we can call that as a false imprisonment. We will come to the definition of nervous shock. Nervous shock is of comparatively new origin. It provides relief when a person may get a physical injury by merely by the nervous shock through what he has seen or heard. He is not hurt by a bullet or a bat or a sword, etc., but rather by the use of words. His entire nervous system has shut down, and for that reason we call this as a nervous shock. In the case of defamation, defamation is considered to be an attack on the reputation of the person. Defamation is of two types, libel as well as slander. Libel is considered a much more permanent form, that is, it is in written words, pictures, cinemas, statues, recorded words, etc. And normally this will have a higher punishment than slander, which is merely a statement against the reputation of the person. Since words and statements are temporary in nature, they will attract a much lower punishment than that of libel. The next concept is known as negligence. Negligence simply means carelessness, wherein one person is required to behave in a certain way and does not do it. Example is the case of a lifeguard. So in Indian Medical Association versus VP Shanta and others, they're saying that medical practitioners are brought under the ambit of Consumer Protection Act 1986 under section 210. So the medical treatment was considered to be a service, and medical practitioners could also be held liable for deficiency in services. In Poonam Verma versus Ashwin Patel, they said that negligence should include 1. A legal duty to exercise due care. There's been a breach of that duty and there have been damages as a result of it. So we can see that even in the case of a medical industry, they are considered as a service, and if they provide deficiency in service, they can still be sued before the court of law. Our last topic that we're looking at is the case of malicious prosecution. In malicious prosecution, I'd like you to remember it this way. There is a suit 1 and there is a suit number 2. Now, the plaintiff in this, I will call as Arun, approaches the court of law against Bhaskar, who is your defendant. Now, in this first suit, it looks like there must have been some genuine reason for which Arun has taken Bhaskar before the court of law. But during the course of the proceedings, it is believed that Bhaskar has been cheated by Arun because of certain wrongful activity that Arun has committed. So let's say in the present scenario, the court has ruled in favor of Arun, and that has left Bhaskar at an inconvenience. Now what they're saying is that if Arun had actually acted maliciously, that is without proper motive and not to further the ends of justice, then the law is providing a certain remedy to Bhaskar. They're saying that now Bhaskar can become the plaintiff, again going to the court of law, and call the defendant Arun for malicious prosecution. Okay, so this is how I need you to remember this point. Let's read the provisions. There must have been a prosecution of the plaintiff by the defendant. So generally a prosecution is started by the plaintiff itself. So if there was a prosecution started by the defendant, we are referring to the defendant in the second case over here. Now this defendant was called before the court of law by the plaintiff, and the plaintiff had a reasonable cause for that prosecution. The defendant, that is Arun, had acted maliciously in case 1, and as a result the plaintiff suffered damages or harm in the case 1, and the prosecution must have terminated in favor of the plaintiff. That means due to some harm, the court ended up favoring the plaintiff in this current situation and not the basker. So finally, there must have been, in the earlier suit, there must have been a prosecution. There must have been a genuine reason for that prosecution, and the defendant or the plaintiff in that scenario acted maliciously. The defendant ended up suffering as a result of it, and finally the prosecution must have terminated in favor of the plaintiff himself. In such a situation, the affected person can approach the court of law for a case of malicious prosecution. Now if we have to look at the liability of a corporate entity in torts, what they're saying is that companies are not natural persons. Therefore, the corporate veil has to be lifted and the employees will be held liable for the wrongs committed by the company. So in short, the corporate veil can be lifted to punish the persons running the company under the legal maxim that says qui facit alium facit per se, he who acts through another is acting himself. Now, tort has arisen even in the concept of Consumer Protection Act as well as in the case of medical negligence. Okay, so if we have to look at certain case laws, that is Branch Manager of Indigo versus Kalpana Rani Debarma and others. Here, the Indigo Airlines had forcibly taken the boarding passes of the complainants and no effort was made to compensate them for their next flight to Agartala. Over here, the NCDRC held that it is not in dispute that the complainants were put to a lot of mental agony and inconvenience and had to stay in a hotel for 2 days. The court eventually ended up revising the petitions with the cost of 20,000 rupees to be paid to the complainants. Bolito versus City and Hackney Health Limited. The following cases have to be assessed in the case of medical negligence: whether the medical practitioner acted as per a practice accepted by a competent medical practitioner, and if not, whether his deviation is justified as being reasonable. If both of them are there, then the medical professional will not be held liable. So as we can see, the medical practitioner can be punished under Consumer Protection Act, under civil liability for negligence, and criminal proceedings under the BNS. And this, friends, is the end of your chapter number 5, that is your law of torts. To do a quick recap, we had done the definition of tort, we had gone through the general conditions for liability in a tort, we had seen what mens rea was and subsequently the 3 types of liability. your strict liability, absolute liability, and vicarious liability. We've looked at provisions from the aspect of vicarious liability of the state, and after that we have come into what are certain torts committed against the bodily freedom or against persons. And lastly, we saw a case of judicial remedies as well as extrajudicial remedies.